So today we will be discussing about divorce. Divorce is a very common word that every one of us is familiar with. But we will be dealing with all sorts of grounds that is available for the purpose of divorce under the Hindu Marriage Act of 1955. So divorce is defined under section 13 of the Hindu Marriage Act. So basically, what is divorce? Divorce is nothing but a legal decree, that is a final order which is passed by a court or a judge, by which a lawful marriage is dissolved. That is, a marriage is annulled, it's made void, and thus both the parties to the marriage, that is the husband and the wife, are made independent of their responsibilities and liabilities against each other. So who can seek a divorce? This is one of the most easiest question that you will ever hear. But still, any legally married person, whether he is the husband or the wife, he may seek a divorce. So whether a party to a marriage is the husband or whether a party to the marriage is the wife is not a barrier for seeking divorce. Either party may approach the court in order to obtain a decree for divorce. Now, what are the grounds for divorce? Or when can someone seek divorce or ask for divorce? So there are various grounds laid down under section 13 of the Hindu Marriage Act with respect to divorce. The first of them being sex outside marriage. So either party to the marriage may seek divorce on this ground when, after the solemnization of the marriage, that is, both the parties have had sexual intercourse with each other, or a sexual relationship has been established between the parties, either of the party has had voluntarily sexual intercourse with any other person other than his or her spouse. So that is one of the grounds for divorce under section 13. Next comes cruelty. So after the solemnization of the marriage, if either party to the marriage treats the petitioner, that is the person who is seeking the divorce, with cruelty, then the person against whom such cruelty is meted out may seek divorce on the ground of cruelty. Cruelty here can be both physical as well as mental. Next comes desertion. So when the petitioner or the person who's seeking divorce in this case has been deserted by the other party to the marriage for a continuous period of not less than 2 years, then that can be a ground for divorce under section 13. The expression desertion actually means the desertion of the petitioner by the other party to the marriage without any reasonable cause and without the consent or against the wish of the petitioner. And it might include the willful neglect of the petitioner by the other party to the marriage. Next comes conversion to other religion. So if either party to a marriage has ceased to be a Hindu by conversion to any other religion, then that is a ground for divorce under section 13 of the Hindu Marriage Act. Next comes unsound mind or mental disorder. So after marriage, if it is found that either party to the marriage has been incurably of unsound mind or is suffering continuously or intermittently from mental disorder, and the disorder is of such a kind and to such an extent that the petitioner, that is the party to the marriage who is seeking the divorce, cannot reasonably be expected to live with the respondent, that is the party against whom the divorce is being sought. So that is a ground for divorce under section 13 as well. So in order to explain mental disorder, we might say that it's a mental illness, or it might be described as an arrested or incomplete development of the mind, even a psychopathic disorder or any other disorder or disability of the mind, and it also includes schizophrenia. So when we say about psychopathic disorder, it means a persistent disorder or disability of mind, whether or not including subnormality of intelligence, which results in abnormally aggressive or seriously irresponsible conduct on the part of the other party, that is the party or the husband or wife against whom we are seeking divorce. And the disorder might be such that it might require medical treatment, it might not require medical treatment as well. Next comes incurable leprosy. So since the act was formulated in 1955, and at that time leprosy was something which was considered really a dangerous type of disease, so this has been treated as one of the grounds for divorce as well, provided it has to be proved that the petitioner has to prove that the person against whom he or she is seeking the divorce has been suffering from a virulent and incurable form of leprosy. Next is sexually communicable diseases. So if the petitioner who is seeking the divorce can prove that the other party against whom he or she is seeking the divorce has been suffering from a venereal disease, that is a sexually transmitted disease, in a communicable form, then that is a good enough ground for divorce under the Hindu Marriage Act. Next comes renunciation of family life by becoming a hermit or sadhu. That is, when one of the party to the marriage has renounced the world by entering any religious order, then that is a ground for the other party to seek a decree for divorce. Next comes not heard of as alive for 7 years. That is, when after marriage either party to the marriage has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of it, or had the party been alive they would be aware of it, then in that situation the court may grant a decree for divorce under section 13. So these are all the primary grounds for seeking divorce under the Hindu Marriage Act of 1955. But these are also the primary grounds for seeking a decree of judicial separation under section 10 of the Hindu Marriage Act. So basically, like divorce, any party to the marriage might seek a decree for judicial separation instead of a decree for divorce by pointing out any of the grounds mentioned above. So when a decree for judicial separation is passed, it is also no longer mandatory or obligatory for the petitioner, that is who has sought the relief under judicial separation, to cohabit with the respondent. But the court may, on the application or by petition of any of the party, and on being satisfied of the truth of statements which are stated before the court, can rescind or cancel the decree if it considers it is just and reasonable to do so. But with respect to all the grounds mentioned above, there are 3 grounds on which the court is bound to give a decree for divorce instead of a decree for judicial separation. Those grounds are, firstly, if divorce is being sought on the ground of conversion to any other religion from Hinduism. Secondly, if there is complete renunciation of this world and by one of the parties to the marriage and entering into a religious sect or order like becoming the hermit or the sadhu. And thirdly, when one of the parties to the marriage has not been heard of for being alive for a period of 7 years. These are the three grounds on which a court has to pronounce a decree for divorce and not a decree for judicial separation. Other than these three, for any of the grounds mentioned above, a court might, even though a divorce is being sought, if the court is satisfied or if the court thinks fit, it might pronounce a decree for judicial separation. Now, other than this, there are other grounds under which a divorce decree might also be sought. One of the grounds is no resumption of cohabitation for a period of 1 year or upwards after the passing of a decree of judicial separation. So just as I just described here, judicial separation, so maybe the court passes a decree of judicial separation first, and then even after the passing of the decree of judicial separation, the court comes to know that after the passing of that decree, a year has elapsed and there has been no resumption of the cohabitation between the parties to the marriage. So in such a case, the court then might change the decree of judicial separation into a decree of divorce. Next, no restitution of conjugal rights for a period of 1 year or upward after the passing of a decree of restitution of conjugal rights. So restitution of conjugal rights is defined or mentioned in section 9 of the Hindu Marriage Act. So like divorce and judicial separation, any party to the marriage, that is either the husband or the wife, can file a decree for restitution of conjugal rights. But as the word itself says, this petition seeking for a decree under restitution of conjugal rights can only be filed when there has already been a withdrawal by the parties from the society of each other. That is, both the parties are not living with each other. In such a situation, any of the party may apply by a petition for restitution of conjugal rights. And if the court is satisfied that all the statements are correct in the petition and there is no legal reason why this application should not be respected or granted, then the court will order a decree for restitution of conjugal rights. So in this case, if such a decree or order of restitution of conjugal right has been passed, but still even after the passing of such conjugal rights, no cohabitation or no restitution has actually taken place and 1 year has passed or more than 1 year has passed, then the court might annul the decree for restitution of conjugal rights and instead grant a decree of divorce. So these were actually the rights or the grounds under which both the parties to the marriage, that is the husband as well as the wife, can seek divorce under section 13 of the Hindu Marriage Act. Now, there are some special grounds only for the wife. Means there are some grounds under which only the wife can seek divorce. So, the first ground is if the husband remarries or already has a wife living. So this is quite self-explanatory. If a husband already had a wife at the time of marrying the petitioner, or even with the petitioner alive, is still married to another person, then the petitioner might file a suit or a petition seeking for divorce. But one of the things to be careful about is whenever a petitioner, that is the wife in this case, is seeking for a divorce on this ground, the other wife, whether the former one or the next one, has to be alive at the time of the presentation of this petition. The second ground is after marriage, the husband has been guilty of offenses like rape, sodomy, or bestiality. This is a clear ground for seeking divorce by the wife. Next is when a maintenance award has been granted in favor of the wife. The award can be granted in a suit under Section 18 of the Hindu Adoptions and Maintenance Act, or in a proceeding under Section 125 of the Code of Criminal Procedure, or under Section 488 of the Code of Criminal Procedure. And after the passing of such decree, there has been no cohabitation between the parties. One thing has to be kept in mind, that whether the wife was staying with the husband or not at the time of passing this decree is not of importance. The thing is that after passing of this decree, if it is proved that there has been no cohabitation between the parties for 1 year or upwards, then the wife may seek divorce under this ground against the husband. And lastly, when the wife was married, irrespective of whether the marriage was consummated or not, before the age of 15 years, and when she attained that age of 15 years, she had repudiated this marriage or did not accept this marriage, then that is a ground for divorce, and under that ground she might seek divorce against the husband, provided she has repudiated this marriage before attaining the age of 18 years. So that is all with respect to marriage and divorce. So we will look into another interesting topic the next time we meet. Till then, goodbye. Thank you.